Hi there, and welcome to this night before notes lecture for the FE1 Tort exam in October 2024. My name is Kieran Lawler, and I'm one of the lecturers here in City Colleges. I've been lecturing Tort for a number of years now, and I'm very happy to be doing this night before notes lecture with the hope that we're going to hit a topic that might come up on the exam and might give you guys some advantage when it comes to sitting the exam. This is a very short lecture, and necessarily it's going to have a very limited scope. We're going to have a quick look at the exam. We're going to talk a little bit about question selection and really, I suppose, emphasize some of the challenges posed by tort law and what that means for you guys as candidates and the approach you should take to the exam generally. And then we're going to look at one sample topic. In this occasion, we're going to take a look at the law in relation to passing off. So the exam, as you know, is a 3-hour exam. Of course, if you're doing it remotely, you get an extension. And I think in reality, it's a great idea to do it remotely. I think most people nowadays type a bit faster than they write and probably type a bit neater than they write as well. So there seems to be no disadvantage to doing it remotely, and you get the advantage of extra time. So certainly anyone who hasn't already made that decision or is thinking about it for future sittings, I'd highly recommend doing the exam remotely. There will be 8 questions on the exam, and in general the layout is 5 problem questions and 3 essay questions. I don't think that's mandatory. The examiner could vary that if they want to, but that's been the position for a number of years now. In terms of the exam itself, then you must answer 5 questions. And when I say you must answer 5 questions, that's not just an instruction from the examiner. It's also just the reality of what's necessary to pass the exam. We now have a body of papers that have come back from the tort examiner that we see corrected, and we can see the kind of marks that are given out for different types of answers. And in reality, it's very clear that the examiner marks on a very narrow band for a reasonable answer. So if you're doing a reasonable answer, you're going to get somewhere between 9 and 11 marks. Really hard to get 12, really hard to get 13. And so if, for example, you were to do 4 questions on the exam, you would need to be scoring a minimum of 12.5 marks per question to get to a passing mark of 50. And that's a really, really tough ask with this examiner. Yes, a candidate might get 13 for a question, they might get 12, but it's really hard to get that consistently. And the examiner isn't generous in that sense. I would, on the other hand, say that I've seen some questions which are not great get the necessary passing 10. And that feeds into the next point, which is that you're way better off starting your 5th question and getting those easy initial marks that this examiner does give out than trying to get, you're polishing your answer to try and get it up to a 12 or a 13. It's going to be really difficult for you to do that. And you're going to pick up way more points by starting your 5th question. In terms of your exam technique, I think you should try and make it easy for the examiner. Do things like start a new answer on a new page. But more than that, you should also know your own timing. And that's about making the exam easy for yourself. And when I say know your timing, you should have an idea in your own mind how long you want to spend reading the paper, how long you think it's going to take you to do your questions. And you should be thinking about that, not just in terms of the number of minutes, but knowing what time you're starting the exam at and what time on your clock you need to be moving on and hitting your markers and moving to the next stage. The other bit of exam technique that I think is really, really important is just to read the paper really carefully, check who you're advising and what you're advising about. The questions often will say at the end, advise Mary as to whether she has a cause of action in a particular tort or against a particular person. And sometimes that question at the end of the scenario in a problem question will significantly narrow the scope of what you need to talk about. And particularly the questions that look like general negligence questions often focus down onto an issue of causation or an issue of the standard of care, depending on what that last bit of the question is. And you can end up spending a lot of time wasting time talking about things you don't need to talk about if you don't read the question fully. One horrific example of this is a couple of years ago, there was a question on the exam where candidates were invited to discuss employers' liability for the actions of their employees. And a lot of candidates just saw employers' liability, circled it, and off they went, talking about the Safety, Health and Welfare at Work Act and the implied contractual duties and the way in which the common law and the tort of negligence brought those together. But of course, the phrase employers' liability for the actions of their employees is actually another way of saying vicarious liability. So the person who read the question briefly, skim read it, and just focused on the big words employers' liability went the wrong way entirely. So it's really important to read the paper carefully. The next point to make about the course is just that it's an extremely wide course. Some courses are not wide; they're narrow. There's a small number of topics that the examiner examines, and it allows you to go very deep on those topics so that you've got a really, really thorough knowledge of them. Tort is not like that. The examiner spreads his questions around from topics that are asked all the time to ones that are much less frequent. And what that means for us is that, and for you guys as candidates, is that you have to try and cover as many topics as you can, obviously starting with the ones that come up most frequently, but going as far down the depth chart, if you like, as you can, so that you've got something to say about as many topics. And I think so what I'm saying to you is, where some exams allow you to go choose a narrow range of topics and go very deep on them, I don't think Tort allows that. I've always said to my candidates, you should be going wide and having shallow. And that, as we'll see, leads to another issue in relation to problem questions, because when you go wide and shallow, while you have something to say about every topic, it can be very difficult to find enough to say about some of the essays. And we'll talk about some of those essay questions in just a minute. But my general advice is that you should prefer the problem questions over the essay questions on the exam. The problem itself, the facts given to you, will help structure your answer. They'll help you find the bits you want to talk about. They'll help you also to recall some of the important information from your studies. And one of the key things when you're doing a problem question is to avoid undirected information. When you're talking about when you're deciding what information to put into your answer, you should always be able to answer the question, why am I talking about this? So when you're talking about a case, at the end of discussing any particular case, you should be bringing it back to the problem question, impacting it back and saying, and so from that, we can conclude, or from that, it's probably the case. So, any question, any problem question you're dealing with, when you're talking about a case that helps you explain your answer, make sure that you're impacting it. And so we say ISAC here as being a structure that most people are familiar with for problem question answers. I think it's a really useful structure. But one of the things we see people not doing is actually the A part, the application. And I think the easiest way to trigger yourself to do that is to ask yourself, why am I talking about this case? And then include that answer in your answer. If you do have to do an essay, and we'll talk about, we'll look at some samples of the tricky ones in a minute, but if you do, what you'll see is that all the essays have some idea or thesis or almost like a debate motion, and you have to choose whether you're going to be in favour of it, against it, partly in favour or partly against. Now, the questions don't say that, they say critically discuss, but critically discuss means exactly that. You must decide whether you agree or disagree with the question, and you must give your reasons for that. The essays are very rarely simply an opportunity to be a black letter lawyer, to simply say what the law is. And it's one of the reasons why I think they're best avoided as well, because what we're used to as lawyers is saying what the law is, describing the law. But the the essay questions ask us instead to be prescriptive, to say what the law ought to be, and that's a sort of an exercise that we're not always as comfortable doing. And so just to take a look at some of the tricky questions that have come up, you can see here the role of fault in the allocation of tort liability has outlived its usefulness in the modern world, particularly with new emerging technologies. Critically discuss this statement in light of the role and function of tort law in the modern legal system. So here you've got to decide, do you agree or disagree with the sentiment expressed in the first statement? You must focus on the function of tort law in the modern legal system, and you have to have some ability to discuss the kind of emerging technologies that the examiner might be wanting us to discuss, and you've got to somehow link that back to the various theories of tort liability and of fault-based liability in particular, and contrast fault-based liability with strict liability. Now, of course, we do a little bit of that in our opening lectures, talking about the nature and role of tort law here in City Colleges, but it's a very tricky essay to structure, requiring you not just to know about tort law, but to juxtapose tort law against an almost sociological understanding of the world in which we live in. So you must paint a picture of the world and the role of emerging technologies in that, and then sort of overlay fault-based liability and decide whether it still has a role to play. That's tricky to do. Critically discuss the reform of defamation law, paying particular attention to the need to protect the reputation of plaintiffs. Sounds easy. You get to discuss defamation law. Looks like an essay just discuss defamation, but in fact, you're particularly asked to suggest some reforms for defamation law. And that's obviously a little bit easier nowadays because we know there's a bill in the offing. But you know, these are the kind of questions that if you haven't gone and looked at the bills, you're going to find it really tricky to do that. So similarly, critically evaluate the classification of damages in tort actions, and in particular the role of punitive and exemplary damages. It's not enough to just tell us what the different classifications of damages are: compensatory damages, special damages, and general damages, punitive, exemplary, nominal. You certainly need to do that, but then you need to critically evaluate that classification. What does that even mean? What does critically evaluate the classification even mean here? What does the examiner expect? I'm not sure I know what the examiner wants here. And it must be very, very difficult for a candidate going into an FE1 exam with all the stress and pressure that entails to look at one of these essays and to not just go down what I think is a trap of simply talking about what the law is. So I think you should try and avoid these kinds of essays if you can at all. That said, essay number 1 on the list there obviously does give you the opportunity to sort of just ramble about tort and fault allocation, and to throw out some stuff about AI or whatever it is. And obviously question 5 and question 7 do give you an opportunity to present what you know about the law on defamation or the law on damages. But just remember that it's not sufficient to simply present the law in those questions. You must go that extra step and do the critical discussion of the critical evaluation part. So before looking at any topic then, I just want to just have a quick look at the exam grid. And you can see that there are some topics that are bunched up towards the top of the exam grid. But equally, you can see that over the years, if you look at August 20, liability for fire came up for the first time, have not come up previously. On the same exam, we also got negligence of children, and we got res ipsa loquitur. 3 topics from the bottom end of the grid. And if in fact you didn't have limitations periods covered, you could find yourself really struggling to find 5 questions from the top half of this exam grid. And it's a good example of a paper where you could have come a cropper if you didn't have that wide and shallow approach to the exam that I'm advocating. Some people might tell you that they can surmise what's going to come up on the exam. I think that's impossible to do, except all you can do really is look at the exam grid and try and pick out what topics haven't come up, but that we know the examiner thinks are important, the ones that are likely to pop up into his exam, up into his mind as he goes to set an exam. I'd look at vicarious liability here. It wasn't in the last sitting, was on 2 before that, was off for 1, was on for 1, was off for 1. So you can see there's sort of an on again, off again approach to it here, and you have to go back a couple of years before you find a few sittings in a row where it hasn't come up. So I would say vicarious liability is a topic that might be giving a little bit of extra time to make sure that I'm good to go on that. Equally, I see occupiers liability here hasn't come up in 3 sittings. It's been a long time since that topic has been left go 3 sittings, and I'm particularly aware of the fact that there's been some reform of the Occupiers Liability Act, so I'd want to make sure I was on top of that area of law as well. And I'd say something similar about medical and professional negligence. You can see that it has been hit a few times in the last few sittings, but hasn't come up in the last 3. So that's the kind of analysis I think you can do to try and ascertain where you should be spending your time, and not spending, but where you should be, maybe if you're going to do a little bit of extra on any of these topics. That's how I'd be choosing the ones that I'm going to spend my extra time on. But having said that, I don't think that you can sort of look at it and say, well, this came up last time, so it's not coming up this time. This examiner will put topics up back to back, several exams in a row, and obviously they're not afraid to ask questions from down the list. So it's going to be very tricky to leave any topic off the exam entirely. So with that in mind, the topic that I want to talk to you about this evening, or this class, is one that didn't come up on the last exam, but does come up relatively frequently, and that's passing off. This is a tort aimed at the protection of business reputation. It's a common law precursor to trademark protection, and it's one of the interesting things about it is that it does present opportunities for us to talk about maybe the role of tort law in a modern society, and maybe passing off as one that you could push back into one of those essays that sort of asks those kind of questions, because there is a question mark over its ongoing relevance in circumstances where we have this really ornate trademark protection regime now. It's also worth noting that that these cases where someone is saying, you're suing, you're taking advantage of my business reputation and you shouldn't be allowed to do that, they often begin as interlocutory injunction applications. That means that someone starts their case, but before they get to a trial, they go into a judge and say, Judge, can you freeze things and stop them from using my business reputation? And there was a recent action before the courts in Ireland in relation to this, in relation to two bars in town. Little Pig was the subject of an application for an injunction to stop one of the people who was trading as Little Pig from doing it because they were affecting the other's goodwill and reputation. And of course, what you'll find is that often the interlocutory injunction settles, the case settles afterwards. We never get a full hearing. And it means you've got to be careful with case law, because when some of the cases and some of the judgments that we're going to look at are interlocutory stage judgments, which means they don't have to be as careful about what they say as to the final outcome of the case. They can be a bit looser because they're not determining the case fully. So just be careful with case law that you don't treat something as if it's a final stage decision if it's actually an interlocutory decision. So if you're doing a problem question on passing off, and I think you'd be hoping for a problem question if it comes up, you're going to begin your problem question in the usual way by saying, I've been asked to advise Mr. X in relation to this issue. The area of law most obviously engaged here is the law on passing off. And then you're going to say that the leading case that sets out the test for passing off in Ireland is McCambridge's and Brennan's Bakery. And under that Supreme Court decision, there are three elements that a plaintiff must prove. They must show they have reputation or goodwill in relation to their brand name and or get-up. And they must show that the defendant has engaged in misrepresentation leading to confusion. And we'll come back and look at that phrase, misrepresentation leading to confusion, in a minute. So that there's some possibility that the offending product might be thought to be to have been manufactured by the plaintiff or to be part of the plaintiff's stable of products. And then there must be damage to the plaintiff's goodwill and reputation by virtue of such confusion. But we'll see that that's not necessarily a strict element when we look at them. So once you've set out what those three things are, in brief, you're going to say, I'll discuss each of those in turn. And that's effectively your roadmap for this problem question answer. You're going to set out that introductory paragraph naming these three items, and you're then going to launch into a discussion of each. So turning to the first issue of reputation and goodwill, the first issue is what kind of factors do the courts give weight to. I'm just going to mention two cases here. On Puss and Irish Permanent, which is an interlocutory stage case where Irish Permanent were trying to launch a product called savings certificates, and on Puss sued to stop them from being able to launch their product under that name. And on Puss had themselves sold savings certificates for 65 years, doing millions of pounds worth of business. And the court doesn't give a clear decision to say, well, if you've done 65 years, that's enough to have goodwill, or millions of pounds of business is enough to have goodwill. But it's clear from the decision that the length of time you've been in business and the amount of a sort of financial business that you've done is going to be something that the court will be interested in. We don't get a definitive decision because obviously all these cases are going to turn on their own particular facts. So we don't get a definitive decision that 65 years is the threshold or millions of pounds of business is the threshold. What we do know is that length of time and amount of money spent on your product is going to be a factor. We also know that from Guinness and Kilkenny Brewing, a case where Guinness tried to stop someone in Kilkenny from setting up a brewing company using the name Kilkenny Brewing because they already had a beer called Kilkenny. And they were successful in that regard. And their evidence of their goodwill and reputation was that they'd engaged in an expensive and intensive advertising campaign, and that there'd also been efforts by people to try and order a pint of Kilkenny before it was even launched. So this was evidence of the success of the advertising and marketing campaign. And so again, the court doesn't say, well, if you've spent a certain amount on advertising, or you've spent a certain amount on marketing, that's going to mean that you necessarily win on the position on having goodwill or reputation. But it does show that those are factors that the court will be interested in. So what we then do in the problem question is we set out these decisions and we look for anything in the problem question that we think mirrors these kinds of features. So if they say that they've had great success with the product, we'll say, well, that indicates that they've probably done a considerable amount of business. If they give any indication of how long they've been in business, we can say, well, they've been able to be successful in business for a certain amount of time. Therefore, that's going to indicate that they've had some success. And so we try and extrapolate from whatever facts we're given the kinds of issues that we see discussed in Post and Irish Current and Guinness and Kilkenny Brewing, and to decide, do we think that this product and this manufacturer or this producer has reputation or goodwill? One other issue that arises is also whether or not your goodwill has to be local. There were a number of early cases in the middle of the last century where the English court said that if you weren't doing business in England, you didn't have goodwill and reputation there. So in Bernardin and Pavilion Properties, the owners of the Crazy Horse Saloon Club in Paris, very well-known nightclub, tried to prevent an imitation club opening in London under the name Crazy Horse, and they lost because they didn't actually do business in London. They did business in Paris. They didn't have goodwill and reputation in London. So that seemed to suggest that you need to be doing business there. The Irish courts, in a decision called CNA Modes and CNA Waterford, recognised that business outside Ireland could give rise to reputation and goodwill in Ireland. There, the plaintiff had a shop in Northern Ireland, and they advertised in Northern Ireland and the United Kingdom, but through media that were carried in the Republic. So UK newspapers that would then be available here, UK television that could be viewed here, and so on and so forth. And the Irish courts had no problem with that. We all would have thought this was a relatively settled point, but there's a recent-ish decision in the last 10 years from the UK Supreme Court called Starbucks, which has nothing to do with coffee and everything to do with Sky TV's product Now TV. And a Hong Kong Chinese-based entity had been using that phrase, and they wanted to stop Sky from using it. And the UK Supreme Court focused heavily on the fact that the Hong Kong entity didn't do business in the UK, to say they didn't have reputation and goodwill. So this came up on your exam. You'd obviously be following the Irish court CNA Modes, but noting that there is this Starbucks decision that reasserts Bernardin and Pavilion Properties and other similar cases. The other point to make is that even when a business closes, it can retain its goodwill. So in Adlib Club in Granville, a nightclub that closed was able to stop someone else opening a nightclub under the same name at the same venue later on because they hadn't yet totally lost their goodwill and reputation in the name. And it's very clear that, if Coca-Cola stopped making Coca-Cola in the morning, people would still know about that brand and be alive to it and aware of it for years to come. And you can obviously get the similar effect on a local level with something like a very popular nightclub, as was the case there. So that's really everything you need to know about reputation and goodwill, or at least it's a sufficient amount that I think you could do a passing answer with it. The next issue is the issue of confusion. And I suppose when we talk about people engaging in misrepresentation leading to confusion, we might get the impression that there must be some sort of nefarious intent or malicious motivation here, a deliberate attempt to piggyback on someone else's goodwill, but that's not the case. This is a tort that can be committed entirely innocently. So there's no requirement to show a mens rea in the sense that we hear that term used in the criminal context. We don't have to show that someone had intent to pass off. So it's very possible this is not, for example, a fault-based liability. It's a strict liability. If your brand, whether knowingly or otherwise, amounts to passing off, you're going to be guilty of passing off, even if you've never heard of the other brand, even if it's not deliberate. So what's the test then for confusion? In Tattinger and Allbev, also known as the Elderflower Champagne case, and you can call these cases by those sort of colloquial names, they're well known and no examiner will criticise you for doing so. In the Elderflower Champagne case, the court said that confusion should be assessed by the average customer of the plaintiff's products. Answer that question, the court said the test should be based on the average consumer in the environment in which they're going to meet the challenged product. Okay, it wasn't about the sophisticated people who consume Tattinger. Rather, it was about the people who might come across elderflower champagne on the shelves of their supermarket. In McCambridge's and Brennan's, the Irish Supreme Court confirmed that. They talked about the impression likely to be produced on the likely customer, taking into account customer perception and imperfect recollection. And I suppose they're taking into consideration the fact that someone who's busy going through a supermarket isn't going to be paying detailed consideration to what they pick up off the shelf, and might just be grabbing something that they think looks like what they're looking for, particularly if they're in a hurry or in a rush. So with those sort of general considerations in mind, where can confusion arise? Well, you can have confusing packaging, as was acknowledged in the Jif Lemon case. You can have a confusing design, but obviously where your design, like your three-stripe logo that Adidas had pushed, where it becomes too popular and becomes just so fashionable, O'Neill's can use that as long as their products are clearly differentiated. And that's what the court said in Adidas and O'Neill's, where there was no passing off because O'Neill's clearly put their own logo on their clothing items. Obviously, the name can give rise to confusion, as can other elements of the product, and we see that in the Allergan and Ocean Healthcare, or the Botox case. There, Allergan manufactured Botox, and Ocean Healthcare were producing a product called Botina, which was instead of being injected under the skin, was placed onto the skin. And but both involved a syringe-like applicator. Both were marketed through GP surgeries. Both were aimed at the same sort of problem, fine lines and wrinkles. And obviously, there's a similarity of names. All those things meant that there was confusion in that case. One issue that sometimes comes up is whether or not there has to be a common course of trade or a similarity of business between the person who's saying that their reputation is being taken advantage of and the person who's supposed to be doing the taking advantage. In Harrods and the Herodian School, the court said that the well-known luxury department store Harrods was not at any risk of confusion from a Herodian school, because nobody would think that the Herodian school, that Harrods were in the business of providing primary school care. And that can be quite important, but it's also worth bearing in mind that where someone launches a product that is complementary but not identical, there can still be a risk of confusion. So in O'Neill's versus O'Neill's Footwear Dryer Company, a Mr. O'Neill launched his own footwear dryers, which I envisage as small hairdryer type elements that would be placed inside shoes to dry them out. And he decided he would sell them in a shoebox, and he would put his name O'Neill's on them. And of course, O'Neill said, okay, there's a similarity of name, there's similarity of packaging, and also the fact, not that this is a sort of a substitute product, but actually a complementary product to the O'Neill's boots that were available. That was all at play in that case. And O'Neill's were successful in stopping the footwear dryers from being marketed in that way. Two other issues just then to be aware of in relation to confusion. The first is in relation to survey evidence. A relatively recent case from the Court of Appeal here told us that survey evidence can be admitted in these cases, but that courts need to be careful about the weight that they give to that. In the High Court, the survey evidence have been excluded as inadmissible hearsay evidence. And of course it is hearsay evidence, but the Court of Appeal said even hearsay evidence can be admitted as long as it's treated and given the appropriate weight. And again, I suppose Galway free range eggs is a relatively recent case. We don't get a lot of cases on passing off. So if you're trying in your answer to try and insert this case into your answer, you might say, if we had survey evidence, that would be admissible, but we don't have such evidence available. So look for those opportunities to set up a sort of a straw man argument that you can then knock down with a case, or that you can highlight your knowledge even where the question doesn't expressly give you the opportunity to do so. It's a fine line. You don't want to get into being not focused on the question that you're being asked and going off on a tangent. But I think there is an opportunity, if you do it in a pithy way, to show knowledge without engaging in irrelevance. Another issue that can come up is celebrity protection. So in Fenty and Arcadia, we saw that Rihanna was able to use passing off as a way to stop a high street shop from launching a range of T-shirts and other garments with her face on it. And of course, the courts in that case, the English High Court and the English Court of Appeal, both said that this does not mean that celebrities get to control who uses their face and who doesn't. This was a very particular situation because Rihanna had a business interest in selling T-shirts with various logos and her face on them, and there was a concern that people in this high street shop might be confused and think that they were getting an authorized or official Rihanna endorsed product when that wasn't the case. And it was that risk of confusion that was sufficient to ground the passing off action in that case. The third element is that of damage. And the first point to make about damage is that it's not a strict requirement. In McCambridge's and Brennan's, the court recognised that, look, if we're at a stage where confusion is likely, if there's actionable confusion, then why do we have to wait for losses to happen before someone can come in and get their remedy? They shouldn't have to do that. And so the courts are willing to give a remedy even where damage hasn't yet been proven. But one example of a case where damage was proven was Falcon Travel Limited Owners Abroad, where there was evidence that people kept phoning each of the companies looking for the other. And so it was clear that the person who'd entered the Irish market from the UK had basically caused the two brands to be melded together in the public's consciousness. And there was clear evidence of damage in those circumstances, of actual damage. And how do you measure that? Well, the damages that were awarded in Falcon Travel Limited were sufficient damages to pay for a marketing campaign to re-establish a brand for the plaintiff. One other point to bear in mind then in relation to damage is just the idea of remedies that are available. The usual remedies are an injunction to stop the passing off and damages for the damage that's been caused. But in McCambridge's, we get confirmation that there's another remedy called account of profits. And an account of profits allows McCambridge's to go into Brennan's and see how much they earned from the bread and to get the amount of profit they made paid to them as a measure of damages. And of course, in these high commercial cases between rivals, it can be very beneficial to have that access to your opponent's information about what their costs are and what their profit margins are, and to see where you might be at risk. So there's a commercial benefit to the remedy of account of profits. So look out for the opportunity to mention account of profits, and McCambridge is number 2. So that's really everything I want to say to you about passing off. There are no particular defences for the action of passing off. It's one where the defence is based on looking at the elements of the tort and trying to hit back and say, no, this isn't satisfied. And so that really is everything I want to say. I hope that is something of use to you. I hope ultimately the passing off comes up on the exam, and this is something that you get to use. And apart from that, I just want to wish you the very best of luck in your exam, and hopefully you won't be coming back to have to redo your FE1 tort exam. All the best. Bye-bye.